After extensive deliberations, we are happy to announce the Supreme Court has reached a unanimous decision on all the 4 issues that fell for the determination in presidential election petitions number 3, 4, and 5 as consolidated. The following is the unanimous decision of the election held on March 4th, 2013, was conducted in a free, fair, transparent, and credible manner in compliance with the provisions of the Constitution and all relevant provisions of the law. It is the decision of the court that the said elections were indeed conducted in compliance with the Constitution and the law. As to whether the 3rd and 4th respondents were validly elected and declared as President-elect and Deputy President-elect of the Republic of Kenya, respectively, by the 2nd respondent in the presidential elections held on 4th March 2013, it is the decision of the court that the 3rd and 4th respondents were validly elected. As to whether the rejected votes ought to have been included in determining the final tally of votes in favor of each of the presidential candidates by the 2nd respondent, rejected votes ought not, such rejected votes ought not to have been included in calculating the final tallies in favor of each presidential candidate. As to what consequential declarations, orders, and reliefs that this honorable court ought to grant based on the above determinations, the following are orders of the court. Petition number 5 of the consolidated petitions is hereby dismissed. Petition number 4 of the consolidated petitions is hereby dismissed. As to petition number 3 of the consolidated petitions, the prayer by the petitioners seeking a declaration of recomputation of percentages by the 2nd respondent is declined, as the court has no jurisdiction. Regarding orders as to costs, the court orders that each party bears its own costs. The detailed judgment containing reasons for decision of the court will be issued within 2 weeks from today. Orders accordingly. Also, as a court, we must appreciate and glorify the outstanding work done by the teams of counsel appearing before us, including the amicus curiae, the learned Attorney General, in this presidential election petition. You are simply superb. You did excellent research into the issues of law and fact that engaged us in the petition. You helped us immensely in the interpretation of the relevant provisions of the Constitution. You are humorous and dignified. We saw a very healthy collective intellectual collaboration between the young and the older counsel. The mentorship that is going on at the bar must be encouraged. You have helped us come up with some great nuggets in our emerging progressive jurisprudence on electoral justice, as well as raising jurisprudential issues for our own future scrutiny. With this kind of collaboration between the bar and the bench, there is no reason we cannot, in the future, export our progressive jurisprudence to the rest of the world.